Tax cases. So boring. In 1976, there was a crisis among building societies in Queensland. 7 different building societies were in financial difficulty, with the potential for economic devastation for Queensland. In response, the Queensland Government created the SGIO Building Society. Its purpose was to receive and combine the assets and liabilities of the failing building societies. A building society had to be formed by not less than 100 members. So there were 2 classes of shares: shares owned by individual members of the building society and shares owned by the Queensland Government. There had always been a contingency fund operated by the Queensland Government. All building societies had to pay levies, and the idea was that borrowers could have absolute security knowing there was a backup if a building society folded. In the 1990s, the government terminated the contingency fund and returned the money to the building societies. Just over $25 million was returned to the building society now known as Suncorp. The Commissioner for Taxation immediately moved to tax this amount. But there was a problem. Section 114 of the Constitution says that the Commonwealth cannot levy taxes on property belonging to a state. This was money passing from the Queensland State Government to a building society created by the Queensland State Government in which it held a controlling interest of shares. Was the money therefore property belonging to a state? The court ultimately said no, and the tax commissioner got their greedy hands on the money. But that's not why we remember this case. Justice Gummow struck gold when describing the process of constitutional interpretation. He said, "Questions of construction of the Constitution are not to be answered by the adoption and application of any particular all-embracing and revelatory theory or doctrine of interpretation. Nor are they answered by the resolution of a perceived conflict between rival theories, with the placing of the victorious theory upon a high ground operated by the modern, the enlightened and the elect. The state of law of the Constitution at any given time is to be perceived by study of both the constitutional text and of the Commonwealth law reports." This is now a classic statement of the High Court approach to interpreting the Constitution. It is not a theoretical process, but a process reflecting both contemporary reality and the precedents established by earlier decisions of the court.